What sort of bail might you have? Who might give you bail? Oh, a judge, yes. Yeah. For example, Jimmy Lai has just been denied bail and has been remanded in custody. Um, um, but I think was Agnes Chow, she was granted bail. I'll have to read the newspaper report a bit more closely. Um, okay, so a judge, so the two different types of bail. There's police bail and there's court bail. Basically, it's a promise to return to either court or to the police station. It depends on the stage of proceedings. To submit to custody of the police or the court at a given date or time. And there can be conditions attached to bail, like residence, curfew, security, or cash bail, or what else might you have? To live at a particular address, not to interfere with witnesses. There can also be. Sorry, right? Okay, thank you. I couldn't remember. Okay, so Agnes Chow denied bail. So okay. So yeah, so bail then, and also while you're on bail, you're expected to be of good behaviour, because if you commit a further offence, or not a further offence, a offence while on bail, then you might have your liberty removed. So here, so what Bob appears to be saying, that he's not going to do anything to Eddie because he's on bail, and it's directly analogous to the wording in Tuberville, and this is quite a common sort of point in exam questions, so it's worth knowing about this. So as a result, Eddie should not apprehend or expect immediate application of force, and so no assault appears to be made out here. Now, this bit in the square brackets is not part of the answer, but I just want to distinguish between what we've been looking at and conditional threats. So get out or I'll break your neck. That's a conditional threat, your money or your life. Well, they are, that is an assault. Okay, so but we don't have that scenario there. So Reed and Coker is the authority on conditional assaults or conditional threats. Now, okay, it could be argued that there's some associated gesture with this, shaking of fists or, sort of glasses or bottles or whatever. And yeah, that sort of conduct could be sufficient to constitute assault during the argument between Bob and Eddie. But even though there might be additional conduct, that conduct could be negated by the word, could negate any accompanying gesture or conduct. Okay, so here I would say the actus reus is not likely to be established. So if we have no actus reus, we have no crime, we don't even need to think about mens rea. But if we did have an actus reus, and I would say this is not the answer to the question, so I put it in square brackets, then it would be committed intentionally or recklessly. Okay, so that's the first scenario. Okay, so the second scenario, where Eddie, so he was the victim in the first potential offence, but here he's the protagonist, if you like, the perpetrator. So he throws a drink over Bob. So here we're going to consider battery, because there is the application of force via the liquid. So we don't have personal contact between Eddie and Bob. So what about an authority for the fact that you don't need to have it sort of direct, immediate contact? The application of force can be via an instrument or an inanimate object or something, like a gun or a knife or something like that, or a pair of scissors. Fagan again, yes. Okay. So, and the car in that case was the instrument of force there. Okay, so battery then, the actus reus, application of unlawful force against the victim without consent or authority. Now, oh, I must have missed something there. I seem to have the wrong ending there. In this, I say that there's no need for actual injury. So, of course, if he was throwing a hot drink or something, then maybe that would actually injure the victim. But if it's just sort of a cold drink or whatever, or warm drink, warm beer or whatever, then you know, there probably won't be any injury. Just it's just soaked with the beer or the liquid, whatever it is. So no need for actual injury to be caused to the victim. And one authority for this is, you know, it's Thomas, where the defendant simply touched the clothing being worn by the victim. So he was touching the victim through the clothing, and there was said to be the application of force there, but there was no harm. He was sort of rubbing the hem of the dress, I think, as well. And here, I suppose, in one sense, the threshold is very low for battery. You know, any sort of application of force or touching without consent by the victim, you know, can potentially be a battery and a criminal offence. But of course, as we know in Hong Kong, that's not going to work out. It's not in a very practical way, because every day we bump into people and, you know, all sorts of things happen. So then the way the courts have dealt with that, and we're not concerned with that in this case, is, you know, for everyday sort of contact, that there's sort of implied consent to that. So obviously, if you go to hospital, for example, and you have surgery, then the hospital will get you to sign the consent form. So you're consenting to the battery. So, but every day it seems that we impliedly consent to sort of everyday contact with other people. So, so here, that's supposed to sort of help justify the threshold for battery, which is, you know, any sort of application of force. There's no need for any injury or anything. Really quite a low threshold. Okay, so that actually can be a battery. And then, well, there's no requirement for direct physical contact between the defendant and the victim. The contact can be through the instrument of an object, and I've given a few examples here: a knife or scissors or knitting needles or whatever. So if I stab my victim with very long knitting needles, I probably won't come into contact with the victim myself, but, you know, the knitting needles would be regarded as an instrument of use. And of course, in Fagan itself, the car, you know, was parked on the foot. There was no direct contact between Fagan, who was sitting in the car, and also the police officer's foot. So that was held to be sufficient in Fagan and the Metropolitan Police Commissioner. So it is worth knowing, you know, quite a bit about Fagan, because it's useful for a number of points. Okay, so battery's looking, you know, okay-ish. So I think we can mention mens rea here, and the force must be applied either intentionally or recklessly. And the authority for this is the case of Venner, and it has been reaffirmed in sort of in Parmenter. So here, because this offence can be committed intentionally or recklessly, then we say that this is a basic intent crime, or a basic fault crime, if you like. So the mens rea is a lower level than, say, specific intent or specific fault, which would be like intention, or ulterior intent even. So here it seems that, I would say, Eddie has direct intention. So he, you know, deliberately sort of throws the drink over the victim. I mean, if he was just throwing the drink around fairly aimlessly, then maybe that could be recklessness. And you could say that in your answer if you wanted to elaborate on this point. So, but if you said that this was intentional, and usually when people throw drinks like that, they have purposive intention. So remember the definition of purposive intention, where the prohibited result, the application of force, was the defendant's aim, purpose, or objective. Okay, because that direct intention sort of authority, even though it's concerning a homicide offence, is actually applicable to any mens rea of intention to any crime. Okay, so here, throwing the liquid over Bob's head, assuming sufficient aim, if you like, the jury are likely to conclude that it must have been his aim, purpose, or objective, direct intention, for the liquid to make contact with Bob. So here I would conclude, like a sub-conclusion. So we've already had one sub-conclusion vis-a-vis the, if I weren't on bail, I'd kill you. So this is the second sort of sub-conclusion. Eddie's likely to be guilty of battery here. So Section 9, Criminal Justice Act 1988. So for each sort of sub-scenario, set out your offence first, and you explain the elements. So actus reus first, and then if you need to move on to mens rea. Okay, now probably in your answer in the exam you wouldn't mention this point here, but I just want to introduce it at the moment. So we could argue in relation to what's his name, Bob. Sorry, where are no Eddie threw the drink. Yeah, sorry, Eddie threw the drink. So here, Eddie's been drinking alcohol. So couldn't you argue that he might be liable for the defence of intoxication? But this is definitely not a viable point at this stage, because inevitably intention is going to fail, because battery is a so-called basic intent or basic fault crime, and we need to look at the Majewski rule. Okay, so just a moment. Okay, so in Majewski, where the defendant had burned down a hotel where he had previously worked and was in dispute with the previous owner and his former employer. So here in Majewski, the House of Lords made a statement about intoxication, because in Majewski, to get his own back, the former employer, he set fire to the hotel, and before he set fire to the hotel, he became very intoxicated. So here, the House of Lords stated that voluntary intoxication, and we'll see later that when we're talking about intoxication as a defence, then intoxication can be being intoxicated with alcohol or drugs, or maybe glue sniffing, or prescribed medication or whatever. And there are two ways to do it. There's either sort of voluntary intoxication, where you sort of knowingly consume the alcohol, or perhaps involuntary intoxication. An involuntary intoxication could be a sort of like a spiked drinks scenario, where maybe I've got a glass of water here, and then somebody comes in the break and puts vodka in it or something like that. So that would be involuntary intoxication, if I became intoxicated as a result and then I went on to commit offences out in the street or something. Another way to be involuntarily intoxicated would be to take prescribed medicines, and then you know, the prescribed medicines have a strange effect on you. Okay, so the basic rule in Majewski House of Law stated that voluntary intoxication can be a defense to crimes of specific intent. And I've just given some examples, Section 18, murder, burglary with intent, but not crimes of basic intent or basic fault, such as assault occasioning actual bodily harm. Section 20 would be wounding or inflicting grievous bodily harm, or criminal damage, or one form of criminal damage, perhaps simple damage, can be committed intentionally or recklessly. But remember, so voluntary intoxication can potentially be a defense to crimes of specific intent, usually more serious crimes, but not crimes of basic intent or basic fault. But remember, voluntary intoxication can only be a defense to specific intent crimes if he's so intoxicated that he didn't form the necessary mens rea. So here we're dealing with basic intent crimes, basic fault crimes. So at this stage, you know, there's no real argument for Majewski rule to apply. And another thing to remember is that drunken intent is nevertheless intention. So if the intention can be made out in terms of, you know, Hollywood or something, and sorry. Right. So yeah, the drunken intent is nonetheless intent. So if that can be made out that there's evidence that you actually formed the intention, then you have intention and the defense of intoxication can't apply. So here, okay, so we've got to go back to battery. Okay, so we're still dealing with a basic fault crime, basic intention crime of battery. So the Majewski rule will not apply. There can't be a defense of intoxication to a basic intent crime because it's voluntary intoxication. So let's look at the offences that are basic fault crimes. So involuntary manslaughter, where you can have reckless manslaughter, or you can have unlawful and dangerous act manslaughter. And so clearly we can see there that the mens rea might be for the criminally unlawful act. So, you know, some forms of manslaughter will be a basic intent crime, and can be committed recklessly. Section 20 and Section 47 and Section 39 of the CJA 88. Well, I've already told you that they can be committed recklessly, so they are basic fault crimes, and then other offences. But even beyond this list, you know, there would be an even larger sort of list of offences, but these are the common ones that you might come across at the moment. What might be easier is to remember what specific intent crimes there are, because there are fewer of those. So murder, Section 18, theft, robbery, burglary with intent. So burglary, for example, can be committed, you know, there's trespass through entry of a building or part of a building, and then with intent to steal, cause grievous bodily harm therein. So it's perhaps better to have in mind, you know, what are the specific intent crimes, and if you're not dealing with one of those, then, you know, it should be a basic fault crime. Okay, so we will mention we will mention the intoxication defense a little bit later when we're dealing with a specific intent crime. So I just wanted to introduce it at that stage. And I would say in your answer, if you were in the exam, it would be like a mention point. Okay, so the third sort of scenario, if you like, is that Bob punches Eddie to the face and then basically stamps on his head. So here Bob punches Eddie hard to the face. So that, evidence might suggest intention. So like a little bit like when you have evidence of a sort of one punch knockout sort of thing, that there was one very hard blow and the victim keeled over. So here we would have to look at that and then see that the actual grievous bodily harm occurs from the stamping on Eddie's head. So the punch initially is like setting the scene, and then there's a sort of series of events that culminates in the stamping on the head. So it's really the stamping on the head bit that we're focusing on, and it's that aspect that really makes the offence section where you tell me what this section is. So unlawfully and maliciously, by any means whatsoever, wound or cause grievous bodily harm, not inflict, but cause grievous bodily harm to any person with intent to do some grievous bodily harm to any person, or resist or prevent lawful apprehension. So you don't need to remember the last bit too much, but what was the most serious offence? Which number was it? The specific intent crime, and we see that reflected in the penalty, life imprisonment, whereas the others were, the maximum penalty was 5 years imprisonment. Well, obviously the section involves grievous bodily harm, so you have two choices, section 20 or section 18. Yeah, section 18, very good. Okay. So section 18 then, wounds or causes grievous bodily harm. So we're focusing on the causes grievous bodily harm. For some reason, you don't often get wounds, but you can judge that for yourself from the past papers. So a wound has to sort of penetrate, more than the surface of the skin. So very often, wound is, by its very nature, the grievous bodily harm in any event. Okay, and the defendant does so intentionally or recklessly. Now that just means sort of, deliberately in terms of advertent action, but with intent. The ulterior intent is what makes it a specific intent crime. So with intent to do grievous bodily harm to any person, or resist or prevent lawful apprehension or detainer of any person. So normally we don't have to worry about this latter part. It's with intent to do the grievous bodily harm is the most normal scenario for you in the exam. Okay, so unlawfully causing grievous bodily harm is appropriate. Grievous bodily harm means really serious harm. We know that from the homicide case of DPP and Smith, but that, still is valid authority for non-fatal offences against the person. And whether something constitutes grievous bodily harm is a question of fact for the jury to decide. So here, okay, so I would normally ask you whether you think a broken jaw and brain damage is, you know, reasonable, really serious harm. And probably you would say yes, I hope so. Certainly brain damages. Broken jaw could be, depending on the severity of the break, perhaps. And the mens rea. So really we have to, because maliciously is regarded as a superfluous sort of word in some respects, so we have to sort of concentrate on the with intent, the ulterior intent, and look to see whether there is purposive or direct intention. I would say from the evidence here is pretty clear cut that there is purposive intention. So the serious bodily harm, the prohibited result, is Bob's aim, purpose, or objective. Okay, now again, you probably wouldn't even sort of write about this because it's not a viable point, but you know, the sort of non-fatal offences against the person all include some reference to unlawfully and maliciously. So, you know, if the defendant was justified in his sort of actions, there was some necessity to use force in the circumstances, then you know, the offence would be invalidated because there would be, you know, a defence of self-defence on that basis. But here, there clearly is no need for using force. He's just engaging in gratuitous violence, and because he's in a bad temper. And even if you did find, well, he did honestly believe that it was necessary for him to use force to defend himself, he's used too much force, so his excessive force is clearly used. So self-defense is not a viable proposition. Now, back to the point we made before, where intoxication is perhaps more, you know, potential in terms of argument, because it's a specific intent crime. So Section 18 is a crime of specific intent, and there is more potential to argue the defence of intoxication than previously when we've only been dealing with basic fault crimes. Okay, so this is the slide I showed you before, the Majewski rule. House of Lords stated voluntary intoxication can be a defence to crimes of specific intent, but not crimes of basic intent. But remember, however, voluntary intoxication can only be a defence to specific intent crimes if the defendant is so intoxicated that he didn't actually form the necessary mens rea. And Sheehan and Moore, you know, drunken intent is nonetheless intent and approved of by Kingston. So here, even though the crime is one of specific intent, the defence, I would say, is likely to fail because Bob doesn't seem to be so drunk that he didn't form the necessary mens rea. So stamping on someone's head while they're on the ground, I would say, suggests a fair degree of cognitive function on Bob's part. So it doesn't seem that he is so drunk that it's likely he did, you know, that he did form the mens rea. So self-defense is not, sorry, is not going to be, intoxication is not going to be a defense, even though it's specific intent crime. And actually, in reality, the courts don't make it easy for you to plead intoxication. So they would prefer you not to be able to evade liability by saying, well, I was so drunk I couldn't remember anything. Right, so let's have a think about Phil. So what might Phil plead as a potential defense? Because here we have Bob saying to Phil, if you don't give me some help, you'll get some of this. And then Phil joins in and partakes in the attack on Eddie. So which defense are we considering? Duress by threat. So yes, correct. So remember there are two types of duress. So duress by threats, duress of circumstances. In fact, most of the time in the exam, you're concerned with duress by threats. So here, duress by threats. So it's like do this or else. Something very nasty is going to happen to you. And it has to be so nasty that it's a threat of death or serious personal harm. So duress is actually limited in scope by the seriousness of the threat, and also it's limited by the fact that it's not applicable to murder, attempted murder, and a form of treason. But of course, because we're dealing with non-fatal offences against the person, then duress by threats is potentially applicable. So here we need to know how the courts deal with duress by threats. What would you say is the threat, the threat that Phil is being exposed to? Yes, the same treatment being applied to her because um, he says, if you don't give me some help, you'll get some of this. And of course, at that time, he stamped on somebody's head. So we would say then, that's pretty obvious, that is a sufficiently serious threat, a threat of at least grievous bodily harm. So let's have a look at the case of Hassan, where Lord Bingham did a bit of a tidying up exercise because previously there had been lots of case law and some of it was a bit conflicting. So he tried to sort of straighten things out. So Hassan is the leading case on duress by threats that we need to sort of cite. So if you remember in Hassan, Hassan had the sort of job as a minder or bodyguard, if you like, to this Miss X, a prostitute, and Miss X had a sort of criminal boyfriend, as prostitutes very often have. So Miss X's boyfriend was S, and he was of a violent disposition, and he was involved in drugs dealing in a drugs gang. And S put pressure on Hassan to participate in an aggravated burglary. So aggravated burglary would be Section 10 of the Theft Act 1968. So Hassan claimed he was coerced, threatened, otherwise you'll get killed. And, these people were known to be very, very violent, threatened Hassan and his family. So sufficiently serious threat there. Hassan also claimed that there was no opportunity for him. It wasn't realistic for him to go and seek the protection of the police. So here it was held in Hassan that duress by threats was unavailable to him because of his voluntary association with somebody connected with a criminal gang, and he ought to have foreseen the risk of being compelled or coerced into committing a crime, so that they would have influence on him in the future, so that his free will would have been coerced or sort of overborne, if you like. But in this case, because of this voluntary association with people who were very likely to do that, then the defence was not available to Hassan. Okay, so Lord Bingham set down 7 requirements, basic requirements, and some of them included the previous test of Graham and Bowen, for example. So we would go through the 7 parts. So first of all, the defendant, in this case Phil, must feel compelled, coerced to commit the offence by the threat of imminent death or serious bodily harm. So that the previous authority before Hassan was Conway. So that doesn't seem to have been a problem. There is a sufficiently serious threat. So Phil knows about Bob's criminal past, is terrified of him, and at the time Bob is engaging in sort of rather extreme, catastrophic sort of violence, and so we know that that's well within Bob's repertoire of behaviour. So secondly, the defendant Phil must have reasonable grounds for believing the threat would be carried out. So because of the points we made before, what's going on at the time, the previous bad character of Bob, then we can say, yeah, okay, Phil will sort of manage to handle this second requirement without too much difficulty. The third requirement, that Phil must be a sober person of reasonable firmness, and how they would have acted in response to those threats. So, the defendant would have to demonstrate a certain level of resistance to the threats. And, here, generally, the more serious the offence, the greater the threat must be. So, the defendant doesn't need to be unduly heroic, but then equally, he mustn't be unduly timorous either. So, a reasonably certain degree of a reasonable degree of steadfastness in the face of threats, perhaps. So here, the threats to Phil are quite extreme. So, arguably, yeah, he would be all right with this point. So let's assume, if you're a bit grey about that and uncertain, you could say, well, on balance, and we'll move on, because we know what's going to be the sticking point, his voluntary association with Bob. So here, it does look as if, that he might be able to satisfy those first 3 requirements. He does join a very serious assault. So the threat at this stage would need to be a very potent one, a very serious one, which it does seem to be. Okay, so the 4th point, Phil must not have had the opportunity to avoid the threat. So, does he have an escape route? Well, in Hassan, it was sort of perhaps seemingly accepted that Hassan has no opportunity to escape or to go to the police. So here, yeah, maybe this is believable that Phil acts in the heat of the moment and he thinks that the threat is going to be carried out immediately. So, you know, it's arguable that this point is satisfied as well. But the point that might be difficult, Phil will lose the defence because, you know, it's arisen as a result of his voluntary association. Well, I've put here criminals, but it doesn't have to be necessarily a criminal. So it could be someone who is likely on from an objective standpoint to exert that sort of influence, which will give rise to a risk of coercion in the future. So Phil knew or ought to have known that by associating with Bob, whom he has knowledge of, that this may put him in this sort of situation. So obviously, following the case of Hassan, now in Hassan, that I suppose there is a distinguishing point because the coercer in Hassan was some sort of criminal drug dealer. And in an earlier case, Sharp, I think I'm going to put a little note about Sharp in these tutorial slides a little bit later. In Sharp, the defendant joined a gang of robbers knowing that they exerted threats of violence, etc., and would potentially coerce the defendant in the future into participating in a robbery. But the key case here now is the case of Ali. So here Ali was convicted of robbery with a co-accused, Mr. X, and they had engaged in a sort of carjacking, robbing an owner of a vehicle while he was in his vehicle at knife point. So here, Ali pleaded duress at his trial because he had joined this duresser who engaged in the robbery of the car owner. So he voluntarily joined the duresser, whom he knew carried a knife and whom he'd been warned not to associate with. So here, the duresser is not a criminal gang, so it's just somebody who carries a knife and doesn't seem to be of good character. So here, the ratio is that if the defendant joins another or others, not necessarily a gang, and in this case it was just one other person, whom he ought to have realised, objective test, might subject him to the threats of violence, then he's denied the defence. Okay, so we apply that test to the Phil scenario, and he joins another, and it could be argued that he ought to have realised that he might be subjected to threats of violence in the future, because he knows the previous sort of character of the defendant Bob. Okay, so I don't think duress or by threats has much of a future. Okay, the last paragraph, we need to have a look at section 47 or section 20, and whether it's ABH or GBH. So do you think the broken nose is ABH or GBH? Okay, so ABH, yeah, it will depend on the medical evidence. If it was a sort of complicated fracture or something, or one of those sort of broken noses that rugby players get, where it's really sort of squashed all over the face, then yeah, it could be categorized as GBH. But you're free to sort of analyze it any which way you like, because it will be a question of fact for the jury to decide. So here then, we're looking at a punch, a battery. So here that Bob applies direct force to Andy, and so there also appears to be direct intention. The prohibited result is aim, purpose, or objective. So looking like we've got the elements of battery, so then we'd have to decide whether it was ABH or GBH. And if we think the battery is caused, the battery's caused actual bodily harm to Andy, you know, an actual bodily harm, you'd have to give a definition. So because it's a concept that you've introduced, so give the definition. And well, I usually use Miller actually. So where actual bodily harm is defined as any injury which interferes with the health or comfort of the victim. Well, clearly a broken nose would, because you know, you must be at least find it difficult to breathe with the broken nose. So here, this is a pretty low threshold actually. You know, any interference or with the health and comfort, well, it could be anything really, so very minimal interference. So clearly a broken nose interferes with one's health or comfort. So yeah, the injury doesn't need to be permanent. It doesn't need to be trifling or insignificant. So here, Bob has caused at least actual bodily harm to Andy. So we'd look then at the mens rea, intentional recklessness. We've given the authority previously. Okay, so let's move on. But in the alternative, consider section 20. Now actually, I think it would be slightly better if I dealt with section 20 first. So maybe I'll change this around. And then the lesser less serious offence of section 47. So here, does the broken nose amount to grievous bodily harm? Now, of course, we don't know what the medical evidence will be, but you don't need to quote the CPS charging standards, but just to give you some idea of what might constitute grievous bodily harm. And normally the examiner won't expect you to know these charging standards, but will expect you to have read case law, and you know, normally in the exam there'll be some injury that perhaps is analogous to a case. So here, indicate injuries resulting in permanent disability, permanent loss of sensory function, injury resulting in more than a minor permanent visible disfigurement, broken or dislocated limbs or bones, compound fractures, and injuries that cause substantial loss of blood. So just some ideas of what might constitute that sort of grievous bodily harm. So yeah, potentially a broken nose can be regarded as really serious harm, you know, approaching Smith. So I think there shouldn't be too much difficulty categorizing that injury as grievous bodily harm. So the facts don't disclose how severe the break was, so limited speculation, I would say, in setting out the most likely possibility. So always try to support the most reasonable interpretation, not necessarily one that's a bit off the wall. So like section 47, there can be a battery, and then there can be intentional recklessness for the mens rea. So surely Bob is at least reckless as to whether he would cause some harm. Okay, and of course we know recklessness has to be assessed from a sort of subjective standpoint. So what about intoxication here? So if he's made a mistake about whether he needs to defend himself, will intoxication make a difference? So intoxication might fail because whether we're dealing with section 47 or section 20, then they are both crimes of basic intent or basic fault. So applying Majewski, then intoxication shouldn't be a defense. But sometimes mistake can be wound up with self-defense. So self-defense might be viable if, Bob really thinks he was about to be attacked. So if the prosecution can prove beyond reasonable doubt, because remember, self-defense is the prosecution, the burden of proof is on the prosecution. So the defense raised the issue and then the prosecution have to prove beyond reasonable doubt that there was no necessity to use the force. The force isn't justified in the circumstances as he perceives them to be, that the defendant perceives them to be. Then that will defeat the defense because he doesn't honestly and genuinely believe that sort of force needs to be used to defend oneself, unless the defendant can argue that he was operating under mistaken belief, and that is possible. But if the mistake is induced by wrongfulness, then the mistake is induced by intoxication, then that will not be a defense. So yes, Bob here, before trying to ascertain the identity of the victim, he punches the victim. So he's using some sort of preemptive strike. So assuming sufficient necessity to use force, then reasonable force must be used in the circumstances as the defendant believes them to be. This is an application of Gladstone-Williams. But can Bob use preemptive strike? Well, it seems yes. So there are two cases. There's we'll focus on Beckford, so that would be the authority there. Also, Debbie Bird is another case that could be used where those points were made. Okay, so the question of whether the defendant's use of force is unreasonable would have to be decided from the perspective, from the standpoint of the defendant. And now these common law principles have been incorporated into a statute. So Section 76 of the Criminal Justice and Immigration Act 2008. And so as long, in terms of whether it's necessary for the defendant to use force, as long as the defendant has an honest belief in the necessity to use force, and I would say he does here, then even if his belief is mistaken and unreasonable, then he might be able to judge, sort of be judged as having self-defense. But if his mistaken belief is induced by drunkenness, then the courts will not accept this. So the defendant, a defendant, may not rely on subjective belief, which results from voluntary intoxicated mistake. So the key case here is O'Grady, which has been approved of more recently in a case called Hatton. Right, and Here again, the provision, the common law principle has been approved by this piece of legislation. So a defendant cannot rely on any mistaken belief attributable to intoxication voluntarily induced. So we've got the statute and the case law telling us this. So here the jury would have to decide whether Bob's mistaken belief as to whether he needed to use force or not, was this due to his voluntary intoxication when he was in the pub drinking, or was it a mistake that he would have made when he was sober? So a little bit of sort of mental gymnastics there. I would say there is we don't know exactly how drunk he was, but even if we say, oh, you know, he did know that it was sort of reasonable in the circumstances for him to he honestly believed that he could defend himself in those circumstances. The second question would be, you know, would a sober and honest person have belief in the need or necessity for the force, but then how much force should be used? Only reasonable force should be used in the circumstances as the defendant believes them to be. The use of force should not be disproportionate or excessive. Okay, so then we would look at the case of Martin, so the lonely farmer, so where he sort of laid in wait for the juvenile burglars who had, well, not particularly them, but similar juvenile burglars had burgled him previously. So, so there he killed, he murdered one burglar and severely injured the other. So there, his reaction, his response was excessive, disproportionate, and so he would not be able to, he was not successful in pleading self-defense in that case. So Anthony Martin. And additionally, we have section 76(6) of the Criminal Justice and Immigration Act. The degree of force used by the defendant is not to be regarded as having been reasonable in the circumstances as the defendant believes them to be, if it was disproportionate in those circumstances. Okay, so probably you know, no self-defense here. Now, do note that this scenario is not a householder scenario. If you have a question in the exam paper where somebody is a householder, then we have to look at subsection 5A, and there is more latitude on the part of the courts to sort of accept what the burgled person can do. So he can plead self-defense as long as what he's doing is not grossly disproportionate. Okay, and then the very last point is that Bob cannot be expected to judge his reaction to a nicety. Oh, by the way, going back to the householder point, you know, this is definitely not a householder point, so we wouldn't be applying that rule. So Bob cannot be expected to judge his reaction to a nicety. So this is expressed by a case called Palmer, 1971, but also subsection 7. Right, so if you look up subsection 7, then you will see that the defendant subsection 7, the wording is very much like in Palmer, and it says, in deciding the question mentioned in the subsection 3, the following considerations are taken into account so far as relevant in the circumstances. So what it's describing here is an agony of the moment type decision. A, that a person acting for a legitimate purpose may not be able to weigh up to a nicety the exact measure of any necessary action, and secondly, that evidence of a person having only done what the person honestly and instinctively thought was necessary for a legitimate purpose constitutes strong evidence that only reasonable action was taken by that person for that purpose. Okay, so he can't be expected to weigh up to a nicety exactly what's going on. He has to act instinctively. So if Bob's reactions are honest and instinctive, then he's got more chance. But of course, if his sort of mistake is as a result of intoxication, then he's unlikely to be able to plead or be successful in pleading self-defense. Okay, so we leave it there. So any questions? I think I have to go to the next room quite quickly and get out of here. Okay, so anything that you're not sure of? Okay, and then you would give some sort of global sort of summing up paragraph at the end.
Okay, can everyone hear me okay? If you can, just type into the chat box for me. Okay, good, right. Okay, so we're looking at constitutional formalities today, and there's usually always a question on this in the exam, and you might decide you don't want to answer this question. Some people don't like this particular topic; they think it's a little bit dry, but nevertheless, it's one that will appear on the exam, and it's certainly an important area to know if you want to really understand how trusts operate. So it's quite important. But let's go through today's problem question, and we'll go through it. And bear in mind there will be a suggested solution to this that will be sent round after tutorial 2 has been completed and all the other groups have done tutorial 2. The space will circulate MMU's suggested solution to this problem. Okay, so you will have a written version of that. So we'll go through that, and then after we've done this, I want to take you through another problem question based on a previous tutorial question, which was itself an exam question years ago, and I'll take you through that and how you might answer it. Okay? Let's start off with the problem question involving ADDI, or AD, however you pronounce that. I have no idea. Where are we? Okay, right. So AD. Let's have a look at this. So first thing to say is when you're answering a question on the on constitutional formalities, ask yourself, has there been a valid declaration of trust? Has there been compliance with any formalities? Has there been an effective transfer of trust property? Now remember, if the settlor declares himself to be trustee, there doesn't need to be any transfer because he already has it he already has the legal title to it. And that does happen in real life. But for examination purposes, usually you're dealing with someone who the settlor wants another person to be the trustee. Okay, because then it involves a transfer and there's more to talk about. So you're usually going to see in that context when you come to an exam question. So again, you've got a problem question involving this area. You need to ask yourself, what does the settler intend? What is he intending here? What does he want to do? What is he trying to do? Ask yourself that, first of all. And ask yourself, what sort of property is involved? Are we talking about land? Are we talking about shares? Are we talking about money? Are we talking about chattels? Okay, what's the type of property we're dealing with? Are there any formalities that are relevant, to those different types of property? What are the relevant formalities? What are the formalities relevant for transferring that particular type of property? Has there been an effective transfer? And if there's not been an effective transfer, can we still save the trust or save the gift by virtue of one of those exceptions that I went through in the lecture with you? Remember, one of those exceptions. 4 exceptions, possible exceptions you can talk about. Well, as I say 4, there's really 3, but there's one that's still good law. We'll come on to that, but it's unlikely to be followed. I'll come on to that shortly. But can we use those exceptions when it's not been complete? Because remember the equitable maxim that says equity will not assist a volunteer, will not assist someone who has not given any consideration. Equity will not assist a volunteer. Equity will not perfect an imperfect gift. There's another maxim. But of course there are exceptions to that. Okay? And it's whether the fact pattern that you're presented with falls into one of those exceptions. Whether you can make an arguable case that it does, or does not even, or does not. And then, of course, you apply the law to the facts of that case, and then you reach your conclusion, the ILAC formula. Remember that there's not always a clear-cut answer to these questions. Okay, often it is debatable, it's arguable, and again, that's why you should never be so absolutist in your answer. Don't say things like, "Oh, this will definitely be a properly constituted. Equity will definitely intervene here and save this gift." You can't say that. Do not say that. Say it's likely that, or very likely that. Okay? That's all you can do. All right. Now, when you're about to write your answer to a problem question, it's always a good idea, when it's involving constitutional formalities, it's always a good idea to start off with a reference to Milroy and Lord. Okay, start off with that, a reference to Milroy and Lord, and you can talk about the different ways in which you can the different ways in which you can give something, give property. So like a legal transfer to the recipient, to the donee, transfer of title to the trustee for someone else's benefit, or even a self-declaration of trust. And what did Milroy and Lord? What did it say about what did it say about perfecting and constituting a transaction and a trust? What did it say? So just a one sentence or two sentences about that. Straight away you get a couple of points. Okay, so start off with a reference to Milroy and Lord. Right. Now, Addy here. Let's start off with the shares. The shares. Is he intending a gift or a trust here? Is he intending a gift or a trust? A gift, good. Yes, a gift of shares to Sanya. Remember, the requirements for the transfer of shares, because we're dealing with shares, that's the property. Remember, you need execution of the, you have to properly execute the stock transfer form. So there's a proper form that has to be filled in. You need to deliver that form, and you either deliver it to the transferee or directly to the company, and then it needs to be registered. Okay, the transfer needs to be registered by the company. Now, on these facts, Addy seems to have, yes, he's executed this transfer form and he's posted it, but he changes his mind. Now, we don't know from the facts whether the shares had already been transferred legally or not. And if the transfer is incomplete, if it is incomplete and it's not complete, then Addy could change his mind and the gift would not be valid, would not be enforceable. And again, this is where you can mention the equity will not assist a volunteer, and equity will not perfect an imperfect gift. Remember, Sanya is a volunteer. She's provided no consideration for this. So that's the general position. But if the transfer is incomplete, could equity nevertheless step in and save this gift? Which one of the exceptions that we referred to in the lecture, which one of those would be relevant here? Which one of the exceptions would be relevant? Somebody tell me which one of the exceptions would be relevant here, which we might be able to, where equity may be able to step in and save this gift, assuming the transfer was incomplete. Is it a DMC? Is this a donatio multis causa? What is it? What could be relevant here? Which one of the exceptions? Is it the rule in Strong and Bird? The rule in re rose, yes. The rule in re rose, otherwise known as what? What's another way of referring to that? The rule in re rose, what can we also call it? Sometimes known as, yes, the every effort rule. The every effort rule. So once somebody has made every effort to divest themselves of legal title, once they've done everything that they could possibly do, everything that's required of them, and it's now out of their hands, then equity may be able to step in and complete that transaction, even though it's not yet been completed, even though it still requires a third party to ratify or rubber stamp something, to a third party to actually do the registration. Equity may still be able to step in here and complete the transaction. Remember, the every effort rule applies to both gifts and trusts as well. Okay, it can apply in both situations. So, has Adi done everything, made every effort here, do you think, on these facts? Do you think he's made every effort? Yeah, we probably. Why? Why? Why do you think that? You can't just say he has. You need to say why you think he's made every effort. Yes, he's posted them. He's posted the forms. He's delivered them. He's done everything that he had to do. So equity may be able to step in here and perfect this transaction, the transfer and the transaction. May be possible. And again, there's always some argument to remember about whether someone actually has made every effort. It's not always clear cut. And if you go back to the lecture and the recording, I talked about re-rose and some of the problems in it. For example, you could argue, he could have done something more. He could have actually written to the company and requested them to register the shares. Is that something? I don't think that is necessary myself, but some people may argue that something else should have happened in between that. Something could have gone further. So how far do you have to go in order to be considered to have made every effort? Okay, so if you want bonus marks or top marks, you could add a little critique about re-rose in your answer and go back to the recording. What I always said about re-rose, and I mentioned a couple of other cases there as well. You could make a little brief critique of the re-rose case, and that would put you into gain you some bonus marks and put you into the higher award territory. Okay. All right. Okay. So that's the shares. Okay. And again, there'll be a written. You'll get a MMU's version of this, a suggested solution in due course. Okay, it will be circulated in due course. Okay. All right. Let's look at the apartment then. The apartment. So what is Adi's intention here? What does he want to happen here with regard to the apartment? Is it a gift or a trust? Yes, a trust. Okay. A trust in favour of Harjit as beneficiary, and he wants Raoul to act as the trustee. Okay. And the requirements to constitute a trust, of course, are that the declaration of trust must be evidenced in writing. That's section 53(1)(b) of the Law of Property Act. And of course, this apartment must be transferred to Raoul as well. Now, an oral declaration of trust is not invalid, but it cannot be enforced until it's evidenced in writing. It needs to be evidenced in writing. Now, that can come at a later date. That's not a problem, but it must be evidenced in writing. Has this been evidenced in writing here? Has it been evidenced in writing, this oral declaration? And again, if so, how? Pull out the relevant facts from the question. Not the deed, not the declaration. That's for the transfer. But we're talking about the declaration here of a trust. The deed is just for the transfer. Do we have what evidence? What do we have in the facts here that show that we could have met the requirement in section 53(1)(b) of the Law of Property Act? Yes, the signed memo. The signed memo. We've got a signed memo. It was found after Addy had died. It was found that would meet the requirements of section 53(1)(b). Okay, it's signed and it contains the terms of the trust. It's signed and it contains the terms of the trust. Okay. Can everyone hear me okay? My computer just froze for some weird reason. Okay, I think I'm back. Can everyone hear me all right? Yes. Okay, right. I don't know what happened there. My computer froze. It was very strange. Anyway, let's get back on track. We've got the signed memo. That would satisfy section 53(1)(b) because it contains the terms of the of this. But we know from you see there in the facts, the apartment has not been transferred because Addy he did execute the deed of conveyance, but he forgot to post it. He forgot to post it. Okay, he forgot to post it. And remember, equity will not assist a volunteer. Is there an exception here that we can apply? Can we apply re-rose here? Can we apply re-rose? Yeah, we can't apply that, no, because he's not delivered the deed. Yeah, he didn't deliver it, so that's not possible. What else might be relevant here? think about what was the case that I mentioned that could be seen as an extension of Re Rose, but it has received a lot of criticism. Remember that case? What was that case? Can anyone remember? Pennington and Wayne. Now, that is still technically good law because it's not been overruled. However, you should demonstrate to the examiner that you know that this is very unlikely to be followed because it's been criticized heavily both academically and judicially, and it's very unlikely, even though technically it's not been overruled, so technically it's still good law, but it's very unlikely that the court would follow Pennington and Wayne. Okay, very unlikely. Again, you can give a little critical analysis of this. Go back to the lecture, listen to the part that there's a lot you can say about Pennington and Wayne, why it would not unlikely to be followed. But what the exception that's most likely here then, that's most likely going to save this trust is what? Which exception? We could apply to this. No, not DMC. No, what else? Strong and Bird. Yes, good. The rule in Strong and Bird. Okay, the rule in Strong and Bird. Otherwise known as what? Margaret. What's that otherwise known as? The rule in Strong and Bird, otherwise known as? Yes, good. Fortuitous vesting. Fortuitous vesting. Now, so that could be relevant here. So, do we have an immediate intention to make the transfer of property? Yes. And that intention seems to continue right up until the death. There's nothing on the facts to suggest that he didn't continue with that intention right up until he died. So, if the transferee, the intended transferee, and that's the who is the intended transferee here, by the way? Who is the intended transferee with regard to the apartment? Who's the intended transferee? Raoul, yes, good. He's the intended transferee because he's the trustee who needs to have the legal title conveyed to him. Okay, so if the way it operates, if that intended transferee coincidentally, accidentally, by chance, fortuitously happens to also be the executor of the will, then this is where we can apply Strong and Bird. Because by being executor of the will means that the legal title will be transferred to him in the capacity of legal executor. And if he just, again, coincidentally happens to also be, just fortuitously, coincidentally, happens to also be the intended transferee, then he will take it. Equity will complete this transfer and say that it's completed. Okay, this is the rule in Strong and Bird. And that could apply whether Raoul is acting as a trustee, or even if Raoul himself was a beneficiary. You know, maybe if Addy could have left this as a gift to Raoul, for example, and he'd still be the intended transferee. It's just that he'd be a donee in that case. But here, he's the intended transferee, but he's actually a trustee. But he's still, either way, he needs legal title. So the rule in Strong and Bird, although that actually, usually we see that in the context of gifts, it can apply to trusts as well. So usually the problem questions will talk about executors because it's easier to develop, but it could also equally, as I mentioned in the lecture, it could also apply to an administrator. So that would be somebody, where somebody's died, where they died intestate without a valid will, and then the court appoints somebody, a personal representative, to administer the estate. And that person's called an administrator, but they're appointed by the court. Whereas an executor is somebody who's named in the will by the testator. You stipulate in your will, if you write a will, you stipulate who you want the testator to be. Who you want the executor to be. So in this case, then, it seems that yes, Rule and Strong and Bird can apply, because Raoul is also the executor of this will, and he was the intended transferee, so he can take the property, the apartment, by virtue of the Rule in Strong and Bird. Okay, good. All right, let's look at the next one. See, it's not that painful, is it? What about the cottage then? The cottage. There's an intention to give the cottage to Dinesh, and the requirements here to perfect this gift, the requirements would be an intention and a transfer. Okay, and it has to be done by deed, Section 52 of the Law of Property Act. But those requirements are not met. So the gift is not enforceable. Equity will not assist a volunteer. Equity will not perfect an imperfect gift. However, what we might be able to argue here is what? What might we be able to argue here? Yes, deathbed gift, otherwise known as the Donatio Mortis Causa. Correct. Yes, DMC. Okay, so what are the requirements for DMC? Well, we can go to Cain and Moon. We can also look at the King and Chiltern Dog Rescue case. And by the way, I did post on the supplementary materials folder on Soul. I did post an excerpt on there, which I strongly recommend you do have a read if you really want to understand Donatio Mortis Causa. It's a Court of Appeal 2015 case, I think it is, and I've excerpted just the main paragraphs. You do not have to read the whole case. The main paragraphs, and that will give you a very thorough, up-to-date exposition of the law on Donatio Mortis Causa. So do have a glance over that, because I think you'll learn a lot from those paragraphs in that judgment. The King case, the King and Chiltern. It's in the supplementary materials folder on Soul. Okay. So we know from the criteria, remember we went through in lecture, there needs to be made in contemplation of imminent death. Okay, so in contemplation of imminent death, the gift must be conditional upon death. So I'm giving you this assuming I die, on condition that I die. And finally, there has to be delivery of the gift, of that property. You have to part with control over it, part with dominion over that property. The criteria there. Now here, AD is clearly contemplating his imminent death. That's not a problem. And but did he make it a condition though? Did he make it an express condition that this is conditional upon his death? Did he do that? Did he do that? Did he need to do that? Is there anywhere in the facts that say that he made it expressly clear that it's conditional upon his death? Has he satisfied that second criterion? Did he make it clear to Dinesh that this gift was only conditional if he on him dying? Did he make it clear? Did he need to make it clear? He didn't make it clear. Did he need to do that? Did he need to expressly say that? Did he need to expressly say that? No, he didn't. No, he didn't need to do. He didn't actually need to expressly say that. That can be inferred from the circumstances. It can be implied. This is the Gardner case, Gardner and Parker. Gardner and Parker. It can be inferred. So, for example, if I'm dying and I give you, I give you access to my entire fortune, my entire bank savings account, then we can infer from that when it's conditional on me dying. Because if a miracle happens and I survive, then of course I don't want you to have all my money. I need that money to live on. So we can infer it from the circumstances that it's conditional upon me dying. Okay. So it can be inferred. What about the third criterion? That you have to part with dominion over it, you have to part with possession over the property. Do you think that's satisfied? Okay, yeah, he gave the key. Okay, he gave them the key. Key to Sadly? The key to Sadly? What's Sadly? To Dinesh. Okay, yeah. Strange typo. Is that predictor text? Anyway, it's yeah. He gave the key to Dinesh, and this is a symbolic delivery. This is like symbolic delivery. So a key to the safe deposit box, and what was inside the safety deposit box? It was the deeds. Okay, the deeds. Okay, the deeds. Okay, and they represent the cottage. Of course, you can't. When it comes to land or real estate, you can't physically hand that over, obviously. So it's what represents that. It's the deeds to it. Okay, so that would probably be okay. That's the Lillingston case, the Sen and Headley case, and that would probably be sufficient. Okay, so it would seem that we have a valid DMC. Now, I can tell you again, these problem questions we're looking at, it's all very theoretical. We're looking at theoretical law. That's what this degree is all about. But I can just tell you in practice, DMCs are very difficult to establish, very difficult to prove. And again, as I've mentioned before, the English Law Commission is currently looking at whether the donatio mortis causa that doctrine should be abolished, because it was abolished in Scotland a few years ago. And because, of course, as you can see, it's open to all sorts of fraud and even miscommunication. Somebody might not be lying, but they may have just misheard or misunderstood what the person was saying when they had it. Or the person might have, they could have been mentally incapacitated, or they unduly influenced. There's all sorts of issues there when with regard to DMCs. So in practice, they're very difficult to establish, very difficult, and it's often when people are claiming them, often it's, again, coincidentally or conveniently, they are the only witness to it. So, the young nephew, his great auntie's dying on a deathbed, and she said to him, "Oh yeah, I want you to have here's the deeds to my property in the mid-levels, or here's my diamond ring that's worth $4 million." And he happens to be, very conveniently, the only person who heard her say that. He was the only one in the room at the time, so there are no witnesses. So, of course, it's very difficult to prove. And there are witnesses. And even if there are witnesses, again, it can always be challenged on the basis that the dying person didn't have mental capacity. Maybe they had dementia or Alzheimer's, for example. Or maybe they felt pressured, unduly influenced. There's all sorts of problems whereas in practice it's very difficult to establish a donatio mortis causa. Very strict requirements. But it's not impossible, and there have been successful cases of it. But it's open to fraud, as you can imagine, and that's one of the reasons, of course, a main reason why there is suggestion from some people, some academics, that this should be abolished. The doctrine should be abolished. I quite like it, though. I think it's an interesting doctrine. I think it's going to be useful in certain circumstances. The problem is, of course, it is open to abuse. Now, I want to ask you this question again, if you remember. This is a question I asked you in lecture, okay, and I did go through it. I find it interesting because I came across this very situation at one time. It didn't go to, in the end, it didn't go to court, and the matter was settled. But it was based on it got to the initial stages, and I had to give some advice on this point. But can a DMC be revoked by a will? Can a DMC be revoked by a will? I gave you the example, remember, in the lecture. I think I gave you an example of a watch, I said to you. Okay, so imagine this. Okay, the line going across the arrow, that represents my life. Okay, and during this, this point here, I make you a DMC. I'm dying. I'm contemplating my imminent death. Okay, I'm pretty sure I'm going to die. I've only got maybe a day or 2 days left to live. Okay, and I meet all of these requirements. Okay, so I contemplate my imminent death. Number one. Number two, I make it conditional. You don't even have to infer that, because I actually say to you, by the way, I'll give you this watch, but it's conditional and I die. Okay, so I've actually made made it expressly conditional. Okay, you don't have to make it. It can be inferred from the circumstances. But let's just say for this scenario, I make it expressly. I hand you my watch. It's a very old, expensive watch. I hand it over to you, and I make it very clear that you can have this if I die. And I actually give it to you. I've handed it over to you physically. So I've parted with dominion over it. I've parted with possession. It's now in your hands. Okay. So there's no question about me meeting all those requirements, 1, 2, 3 of the DMC. Okay. 1 or 2 days later, I die. And when I die, at that instance, that's when my will becomes effective. Okay. Now that's different from when a will is valid. A will becomes valid when it's properly executed. Okay, when you go to the solicitor's office, you sign it, and you've got your witnesses there, and they sign it, and all that. That's when a will is valid. But a will doesn't become effective until the moment you die. Okay. So I die a couple of days later, and my will is read out, and according to my will, I've left that watch to my son. So, who gets the watch? You or my son? Does the will revoke my earlier DMC? Now, do you remember the answer that I gave you in the lecture? You remember the answer? Does it revoke the DMC? Does the will revoke the DMC? You think the son will get it, so you're saying that the will does revoke the DMC, you think? You think the son will get it? No, you would get it. The person, because I gave you the DMC. Now remember, a DMC is a bit of an anomaly, because it's not an inter vivos gift, and it's not a testamentary gift. It's something else. Let's see why. When I die at that moment, that's when my will becomes effective. Okay, but remember, the DMC. It's not an inter vivos gift, so when I give it to you, it's conditional upon me dying. And I'm not dead yet when I give it to you. So what happens? Well, the law will treat the DMC as being an absolute gift as at from this point, X, here. So when I die, the DMC, the earlier DMC, becomes an absolute gift as at from that earlier point in time when I handed over the watch to you, when I gave it to you. So it wasn't a gift then, it wasn't yours then, it only became yours when I died. But it's, if you like, you might call it, it's all like the law backdates it. It's backdated. And the law will treat it as if it was an absolute gift by me, from me to you, as at the time that I handed it over. And that's how the law. So the answer to the question is no. A DMC cannot be revoked by a will. And of course, this can cause issues, especially in like the case I mentioned, that where the will was written about many years earlier. Okay, and the alleged donor of the DMC, the alleged donor maybe had forgotten who she'd left this particular piece of property to. She'd probably forgotten who she'd left it to, or whether she'd disposed of it or not. But then there was a later conflict between one of her relatives and another relative who was named in the will. And one relative saying, no, she gave this to me on her deathbed, and she did have witnesses. There were witnesses there who testified that was the truth. She did give it. There doesn't seem to have been an issue about her mental state. I think it seemed to be okay. The mental state seemed to be okay. There was no real suggestion of Alzheimer's. But there was a dispute between that relative and the person named in the will who was supposed to get that property. Again, it doesn't have to be something expensive. Often these things, it's just sentimental value. It may be not worth a lot of money, but it's a sentimental value. And which one? You can't have there has to be an answer to this. You can't have them. One has to trump the other. And it's the DMC that will trump, assuming it's a valid DMC. And I told you it's very difficult to establish DMC anyway. But assuming you can, then the DMC will trump the will when it comes to that gift. Okay. An interesting situation. Okay, right. So I've given you. We looked at the first problem question, that's the set one, and you'll get a suggested solution to that. But I wanted to give you another example now, because the more of these you see, the more familiar you get with the way the examiner presents them, and you'll see that there's similar themes come up again and again, as we've seen before. Now this one, I hope you've had a chance to have a quick read through it. This is available on Soul. I did draw it to your attention. It's a previous tutorial question and former exam question. Okay, it was an old tutorial question and an exam question as well, based on an exam question. So if you haven't read it, just have a quick skeed. I'll give you 1 minute. Just have a quick, brief look through those facts very, very quickly, and I'll walk you through it, how you answer it. Okay. Let's start off with let's start off with Malmaison. Okay, this one, Malmaison. Okay, so we've got leasehold property here. Okay, leasehold property. So Schuyler is intending a trust with Marie as trustee. So the formalities required here are, first of all, we need to execute a deed in favour of Marie. And this is in section 52 of the Law of Property Act. And in addition to that, we need to register this with the land registry. So this is section 27 of the Land Registration Act 2002. And in addition to that, because we're dealing with a trust of land, it also needs to be manifested and proved in writing. That is section 53(1)(b) of the Law of Property Act. Okay, so we've got section 52 of the Law of Property Act, Section 27 of the Land Registration Act, and Section 53(1)(b) of the Law of Property Act. Okay. Now, although Schuyler seems to have the intention to complete this deed, she hasn't done so. So the transaction is therefore incomplete at law. So we have to look at whether equity can intervene here and save it. Do you think you can argue the every effort rule here? Could we use the rule in re Rose? What do you think? Could we use the rule in re Rose? Seems not. No. Because she's not completed or posted it. She's not posted it even. So she's certainly not met the test in re Rose, the every effort rule. She hasn't done that. What about Pennington and Wayne? Pennington and Wayne. Well, you know, could we argue that on the basis of unconscionability? I would probably say no, we can't. And you can distinguish, first of all, Pennington and Wayne. Because remember, Pennington and Wayne concerned a gift anyway, and we're dealing with a trust now. But even if you can't distinguish it, the point is, Pennington and Wayne, as I've mentioned before, is not thought to be a safe authority. Okay? It's still good law technically, it's not been overruled, but it's not considered to be something that the courts would follow anymore. Okay? It has not been overruled, so that's why we still need to know about it. And then again, an examiner would be impressed if you could explain why it's not considered to be good law. If you go back to the lecture and see what I said about Pennington and Wayne, but why it's not considered to be good law, even though technically it's not been overruled, and the examiner would be impressed if you could explain why. That is very unlikely that Pennington and Wayne would be followed. Okay, so no re-rose, it seems no to Pennington and Wayne. So what do we have? What could we potentially argue here? What could we potentially argue? What could we potentially argue? Yes, Strong and Bird. That's possible because Marie is appointed as executor of Schuyler's will. And there seems to be an immediate present intention, and that seems to go all the way up until she dies. There's nothing to suggest that that intention does not continue. So that means that when the legal title vests in Marie as executor, when it vests in Marie by virtue of her appointment as the executor, then this potentially allows us to consider the fortuitous vesting principle, the rule in Strong and Bird. We can consider that this equity may consider this transaction to be complete by way of fortuitous vesting. The only problem, though, we have is a little problem of Section 53(1)(b). Section 53(1)(b) of the Law of Property Act. Because this is a trust of land, remember, it must be manifested and proved in writing. Now, we know that the writing does not have to be contemporaneous. It doesn't have to be at the same time as the declaration. But the writing must contain all the material terms. This is Smith and Matthews. It must contain all the material terms. So, do we have anything in writing here with all the material terms on these facts? Well, it tells us that Schuyler wrote a contemporaneous covering note. Remember, it doesn't have to be contemporaneous; it could have come later. But we're told that she actually did write a covering note, and she signed it. The problem is that we don't know what the note said. We don't know whether it contained all the material terms. Now, if it did contain all the material terms, then that's fine. We can apply Strong and Bird, and it seems that this, there is a valid trust in favour of Flynn. But what happens to the property if it doesn't contain all the material terms? What happens to the property then? What happens to Malmaison? If the piece of paper that she wrote contains all the material terms, we know it's signed, it's written by her, then Strong and Bird would save this, and there would be a valid trust in favour of Flynn. Okay, most likely. But if it wasn't, what would happen? What happens to the property? Well, it goes to the residuary estate. It goes back. It results back, if you like, then to the residuary estate. Yeah. So the residuary beneficiaries would be the beneficiary, would get that property. Okay. Okay. What about the shares then? The shares. Schuyler intends a gift to Hank, an outright gift. Remember the formalities for a share transfer. You have to complete the relevant stock transfer form, the relevant transfer form. And then there has to be registration in the company accounts. And you can make reference here to section 771 of the Companies Act 2006. Now we know that the form has been executed, the transfer form has been executed and it's been sent, but registration has not yet taken place. So that means at law the transaction is incomplete. So again, can equity step in and intervene here? Can equity save this gift? Re-Rose, yes, Re-Rose. Schuyler has done all that's required of her, so the only thing remaining is the actions of the company in confirming the registration. So the every effort rule, the rule in Re-Rose, seems to be met, is seemingly met here. It seems that it could be applied. So the company could be compelled to complete the transfer in law. Okay, Re-Rose. And then finally, the savings account. Now, if you're going to transfer your ownership of a bank account, of course there are going to be certain formalities. Each bank will, they'll have their own paperwork for this. You've got to fill out the correct forms, etc., etc. There are certain requirements, formalities there, but those formalities have not taken place here. Okay. So, which exception will be relevant? Which equitable notion, concept could come in here and save this gift? Yes, a DMC, donatio mortis causa. Remember the Cain and Moon, or the king and the Chiltern dog rescue case. Okay, so remember, what are the criteria? Okay, so again, assuming the donor has mental capacity, let's assume there's no issue about having any mental illness or any dementia or anything. But assuming she's got mental capacity, which seems to be so here, there's nothing to suggest that she hasn't. She seems completely normal. Remember, the criteria are that she needs to have contemplated her impending death. She needs to have made the gift conditional upon her death, and she needs to have parted with possession of or control over that property. So, let's apply that to these facts then. Well, it seems Schuyler has given the gift in contemplation of death. She's got a terminal lung condition, we're told, and she collapses. By the way, does it make a difference that she died from a different cause? She was actually killed by the stray bullet, wasn't she? It says a stray bullet. Does that make a difference? She thinks she's going to die of this terminal lung cancer, or lung condition, whatever it is. But she's actually killed by the stray bullet. So, does that make a difference? Do you think? She thinks she's dying from the terminal lung condition, but she dies from the stray bullet instead. So, does that make a difference? Yes, that's good. I mean, the answer is no, rather. I was saying, yes, you're right, it's no. The answer is no. It doesn't make a difference. Okay, this is the case of Wilkes and Allington. Wilkes and Allington. Wilkes and Allington. So it doesn't matter that you died from another cause. That does not affect the validity of the DMC. What about the gift being conditional on death? Did she make it conditional on her death? Did she say that it's conditional on her death? No, she didn't. Did she need to make it expressly? Did she need to expressly state it? No, she didn't. It can be inferred from the circumstances. Gardner and Parker. It can be inferred from the circumstances. I mean, why else would she give her whole savings to? It must be because she, we can imply from that, she was in. It's only assuming I die. If I don't die, then of course I want the money. I need to live on. And then we come to parting with possession of, or parting with dominion over the property. Has she done this? Has she done that in this case? Has she parted with dominion over the property? How? Yes, the key. And this is symbolic delivery. Symbolic delivery. This is the Birch and Treasury Solicitor case. Birch and Treasury Solicitor. It's symbolic delivery. Okay, to something to the safety deposit box, which contains her passbook. Now, of course, a bank account is an intangible thing. You can't touch it, you can't hold it, you can't put it in a safety box. But what you can have is a physical manifestation of the bank account, a symbol of it, if you like. And you could argue that the passbook, the bank account passbook, that is a physical manifestation, if you like, of that intangible thing. So that might be symbolic of, that this is over the account, symbolic delivery, parting with possession of. So again, it's not a clear-cut case, and in real life, I can tell you it's incredibly difficult to establish DMC. But here, just from our academic point of view, theoretical point of view, it should be possible. It should be okay. It's likely, I would say, that this on a theoretical point, from a theoretical point of view, it's likely that this would be okay. This would constitute a donatio mortis causa, and so therefore that means Ted is likely to be entitled to the £50,000. Okay. By the way, when it comes to DMCs, does death need to be an inevitable consequence of the identified cause? Does death need to be inevitable? Two conflicting answers there from different people. The answer is no, it doesn't need to be an inevitable consequence. It doesn't have to be. And now, I'll give you an example from the previous problem question. The dangerous surgical operation. I mean, there was a 40% chance of surviving that. So it was a 60% chance. It wasn't inevitable that he was going to die. It was a 60% chance that he would die from the operation. But it's not inevitable. He could have survived. And likewise, what if, for example, I went in for an operation and there is a 5% chance that I will die, right, from the operation. So it's pretty safe, okay? It's pretty safe, 5% chance. But I'm really paranoid, and I'm really worried, and I'm really paranoid, and I think I'm going to die. I'm going for this operation. I just know I'm going to be so unlucky I'm going to die. And I make a donatio mortis causa, and then I do die. Would it be valid? Yes, it could still be, even though it doesn't have to be inevitable. Okay? So long as I'm contemplating my impending death, that should be enough, theoretically. That should be enough. But certainly death does not have to be an inevitable consequence. It doesn't have to be an inevitable consequence. The previous problem question is a good example of that. If you're going for a dangerous surgical operation. All right, another question for you. Can a DMC be revoked by a donor before he dies? So if I make a DMC to you, can I revoke it? So let's say I make a DMC to you of my watch, and then 2 days later, I'm literally just a few hours away from death, and then I revoke it. Can I revoke my DMC, my earlier? Yes, of course you can. You can revoke it up until you die. Yeah. Remember, a DMC is not an inter vivos gift. It's not an absolute gift, absolute inter vivos gift. Neither is it a testamentary gift. It's something different. It's something which, when the person dies, it's backdated, if you like, and it's treated as if it was an absolute gift back at the time when the person parted with dominion over it, when they parted with possession of it. Okay, good. So you see this the pattern, the kind of questions that come up, and again it's the repeated themes again and again, and these cases on this next slide, which you've already got, I've uploaded it to Moodle. I put the guidance. These are all those cases that I put as guidance, the relevant authorities. Okay, if you're familiar with these authorities basically cover most, if not all, of those questions are problem questions on the constitutional formalities. If you know what each of these cases and these statutory provisions, what they say and what they refer to, then you'll be able to answer the question. This is basically all the authorities you need. All the authorities you need. Okay, Margaret's just asked. May I say a DMC can be revoked by a later DMC, but not by a later... Oh, interesting. Okay, so you mean... But how could you part with... If someone's made a DMC, if it's valid, you need to have parted with possession of that. So you need to have given it to that person. But how can you do that to the second person later? Because you won't have anything to give. Oh, okay, duplicate of the key. Okay. Maybe you should write the problem question, Margaret. Well, I don't know in that situation. Yeah, if you get a duplicate of the key. Is there another equitable maxim we could apply here, potentially? There is actually another. You know that I told you about the maxims of equity? There are about roughly about, I don't know, 20 or so of them. You can find them online there. They're in any or in your textbook. What about, is there, I can think of at least two, or certainly one equitable maxim that would be relevant to this. Can anyone tell me what it would be relevant to answer in that question? Margaret's question there about if there was a DMC and the person handed over the key, and then let's say the following day they handed over a duplicate key to someone else. Is there any equitable principle you could apply to that? Any equitable maxim? Because there has to be an answer. There has to be an answer. The law would have to deal with it in some way. I've never come across such a situation, but the law would have to deal with it in some way. They can't just throw their hands up in the air and say, well, we don't know how to answer that. How would you get around that? I can think of at least one equitable maxim that you could apply to try and that the courts could use to try and get around that. Okay, well, if anyone thinks of it, they can let me know at the end. Okay, and tell me what you think. Okay, let's move on to some revision questions. Good question, Margaret. That was okay. Some revision questions. Right, this is just as a. Okay, this one's easy. What does it mean if a person is an absolute owner? What does it mean if a person is an absolute owner? Yes, they have both legal and equitable title. Yes, they have both legal and equitable title. Okay. what is meant by the equitable maxim, equity will not perfect an imperfect gift? Well, again, this is, there are formalities for transferring legal title that we know that exist. If they've not been carried out, the transfer is said to be imperfect. Okay? And this maxim is basically saying equity will not step in to complete the transfer. It will not step in to complete. That's the general position, but of course we know there are exceptions to that. Okay, but that's the general principle there. According to the Law of Property Act, how must legal estate be transferred? Well, of course, when we're dealing with land here, we're talking about transferring it by deed. By deed, this is section 52(1) of the Law of Property Act. And that's, of course, subject to certain exceptions in section 52(2). So do check out that. Look at section 52(1) and then look at section 52(2) because there's some exceptions there. According to the Law of Property Act, how must an equitable interest be disposed of? How do you dispose? So let's imagine in a sort of trust, a sub-trust situation. So I'm a beneficiary under a trust and I want to make someone else a beneficiary of my beneficial interest. So I need to essentially dispose of my beneficial interest. How do I dispose of my beneficial interest? How do you ever, in any situation, dispose of it? This is in section 53(1)(c) of the Law of Property Act. It needs to be in writing and signed. In writing and signed. In writing and signed. 53(1)(c). What are the requirements under the principle in Strong and Bird? Well, we know that again it has to be an immediate intention, an intention to give immediately, and that intention continues unchanged up until the person's death. And on top of that, the intended transferee happens to be coincidentally, accidentally, fortuitously, just happens to be by chance also the executor or even the administrator. Okay. And in that situation, the rule in Strong and Bird can be invoked. It's called fortuitous vesting, and equity can treat that transaction, that incomplete transaction, as complete. Because by virtue of being the executor of the will or the administrator of the estate, you would have the legal title transferred to you in your capacity as that. Okay? If you just fortuitously happen to also be the intended transferee of this otherwise incomplete transfer, then you can take advantage of the rule in Strong and Bird. According to the Wills Act 1837, what are the requirements for making a valid will? Well, this is in section 9 of the Wills Act. Section 9 has to be the will. It has to be in writing and signed by the testator, and of course, it has to be signed by at least 2 witnesses. At least 2 witnesses. Okay, section 9, in writing and signed, of course, with 2 witnesses. Section 9 of the Wills Act. By the way, remember, if anyone ever asks you to be a witness to a will, to when they want to execute the will, just make sure that they don't intend to leave you anything under the will, because if they do, then you will not be able to get it, because a witness cannot be a beneficiary under a will. So if you've got a very rich, great auntie who's, wants to go and write a will, and to the solicitors, and if she asks you to be a witness, then you might want to double check with her that she's not intending to leave you a fortune, because you won't be able to take it if you're a witness. All right. And can a valid trust of land be declared orally? Yes or no? Can a valid trust of land be declared orally? What do you think? Yes, the first person in any of these groups that said yes. The answer is yes, but why is it then, Petrus? Why is the answer yes? Why is it valid? Everyone usually says no, and I know why they say no, but you have to read the question carefully. Why is the answer yes, Petrus? Good. Yes, you're right. It's valid, but it's unenforceable until it has been in writing and signed. Okay, so you can declare it orally. That's valid, but it will not become enforceable until it's in writing and signed. That's section 53(1)(b). Okay, it needs to be in writing, signed. It doesn't need to be executed, though. It doesn't need to be executed by deed. It just needs to be in writing and signed. The deed is for the transfer. We're just talking about the oral declaration here, the declaration of trust. Okay, the declaration of trust. It needs to be in writing and signed. The deed is just about the conveyance of the property, transferring it to the trustee. But with regard to the actual declaration, that is valid if it's oral, but it's unenforceable until it's in writing and signed, section 53(1)(b). Okay? Right. What are the requirements for creating a trust of land with a third party acting as trustee? Well, remember, this comes up a lot in the problem questions, remember. Transfer of legal title. Okay, that transfer is by deed, and that's section 52 of the Law of Property Act. In addition to that, you need to register the transfer with the Land Registry. That's section 27 of the Land Registration Act. And finally, the declaration of that trust, because it's a trust of land, it needs to be proved by some writing and signed. That's section 53(1)(b) of the Law of Property Act. So you're 3 core statutory provisions there. Section 52, Law of Property Act, Section 27, Land Registration Act, and Section 53(1)(b) of the Law of Property Act. This next question is just for the sake of completeness. What does Gray and IRC say about the disposition of subsisting equitable interest? Needs to be in writing. Okay, that's all. It needs to be in writing. Don't worry too much about that for the problem question. And likewise with this one, the Vandervelde. I'm mentioning this because it's quite a very famous, well-known case, because it involves a very complex structure transaction. And there are a few cases about Vandervelde. Okay, but this one, Vandervelde and IRC, we'll come back to another Vandervelde case later on in the course. But I'll just mention here Vandervelde and IRC. Just for the sake of completeness, what exception to the section 53(1)(c) rule was identified in Vandervelde and IRC? Well, essentially, this based on this Vandervelde and IRC, when the owner of a beneficial interest under a bare trust, when that owner, and assuming he's sui juris, he's mentally competent and he's an adult of sound mind, assuming he's sui juris and he's absolutely entitled, then that owner of the beneficial interest under the bare trust, if he directs the trustee to transfer the legal title to a third party, and intends that at the same time that the equitable title also transfers to that same third party, then there is no need to comply with section 53(1)(c) of the Law of Property Act. There is no need for it to be in writing and signed. There's no need for that. So again, when the owner of a beneficial, let's assume he's an adult of sound mind and he's absolutely entitled. When the owner of a beneficial equitable interest under a bare trust, when he basically directs the trustee to transfer the legal title to X, some third party X, and he intends at the same time that the equitable title also transfers to X, then there's no need for him to comply with section 53(1)(c). And finally, we've already looked at this one. Can a DMC be revoked by a will? No. Why? Because a will only becomes effective upon the donor's death. Whereas, once the donor has died, the DMC becomes an absolute gift as at from the earlier time when the property, or control over the property, was delivered, when he parted with dominion over the property. Okay, so it's sort of like backdated, if you like. So the DMC comes first. Okay. Can anyone suggest an answer to Margaret's conundrum? Whereby, what if somebody makes a DMC, and then, let's say the following day or even a few hours later, they pass an identical key to another family member, and then they pass away, they're dead, so that's over. And then there's an argument between those two people. They both claim that they've had a valid DMC. Which one would prevail? There has to be an answer. The law would have to deal with it. How would you deal with it, do you think? Are there any of those equitable maxims that you might be able to apply? I mean, it very much depends on the facts. I mean, there's a lot of factual things we don't know. We don't have all the. So in real life, if that was a real, there may be some other things at play that we can use. Like undue influence. You could say, oh, she was, or whatever. That you unduly influenced her, or you put pressure on her, whatever. But if there's none of that, and everything looks equal, what happens then? Okay, yes, that's a good one. Petrus suggested that he who comes to equity must come with clean hands, but let's assume they both had clean hands. One didn't know about the other. They're both claiming. Let's say relative A first and relative B the following day, and both relative A and B they both come with clean hands. They both they don't know about each other's thing. They both have a claim, and B didn't know that A had already been given this property by way of DMC the day before. So there's no suggestion that she's been, doing anything wrong. Are there any other equitable maxims that you might be able to apply? Equity acts on the conscience, yes, but again, let's assume they've both got clean consciences. They both, they both, there's nothing. Both of those relatives, they're both. Let's imagine they're both nuns. Okay, they're both nuns. Looks to intent, but how can you show intent when the person's dead? How do you know How do you know How do you know what the old lady intended? Equality? But okay, but how would that... Purely on the facts that we know so far that I've given you, everything seems to be ceteris paribus. Everything's all equal. Everything's the same. There's no, let's assume they've both got an identical claim here. There has to be a solution. You can't just say, oh, we don't know. There has to be a solution. So what could you argue potentially? What about, could we say, where the equities are equal, the first in time prevails? Could we argue that? Where the equities are equal, where there's no other way of determining it, could we argue the first in time So the person who was given the key first, if she can prove that she was given it first, then she would, I would suggest that she would be the one who would succeed with the DMC. Because when the old woman died, remember, the DMC is treated as if it was an absolute gift, as at the time, remember, as at the time from when it was first given over, And even though it was be given by the key, it's still symbolic delivery. So it would be that. So it would be the first in time that would prevail. I've not come across this situation before, and I don't even know if there's a case on this. If anyone finds a case, I'd love to know what it is. I've never come across this, but if there was two DMCs, one after another, and there's everything else about them seems to be there's no problem, there's no suggestion of undue influence or duress, or there's no pressure, no nothing. Which one would prevail? Well, if everything else is the same, there has to be a conclusion. So I would suggest the one that came first, the first in time prevails. But is that in the first? Does that mean the first one who was given the DMC, or the first one who makes the claim? Arguably, it would be the person who was given the DMC. Because once that's established, when they were given the DMC, once it's established in time, at what point, and again, that if there's dispute over that, it will just come down to credibility and testimony in court. Which one of those two relatives makes the more convincing witness. But once it's established the point in time, then one of them was given the DMC before the other. One of them was given the key before the other one. And that person, I would suggest, is the person who would win. Yeah. Does anyone have a different view about that? Anyone have any other suggestions? All right. Okay. Right. We'll leave it there then. If you have any questions, you can type them into the box. Otherwise, we'll conclude the tutorial on this one. As I said, after we've done the tutorial 2 cycle, we'll send round the suggested, or MMU's suggested solution to this problem. Okay, we'll send around that. And the first tutorial as well will come around at some point. I don't know. I have to ask the administrator about that to send that around if it's not been sent around already. But don't worry, we've got plenty of time. Right, okay, I'll leave it there, and have a good evening, what's left of it, and I shall, we've got our lecture on Saturday, I think, isn't it? I think our next lecture. Okay, see you virtually on Saturday.